Good morning, everyone. Welcome to this webinar this morning on AI-driven grievances and claims. Lisa, can we go to the next slide, please? So for those of you that don't know me, my name's Andy Boyd. I'm a legal director in the employment team, and I'm joined by my colleague, Joe Cooney. We've both got a lot of experience in acting for employers with advisory work and a lot of individuals and employers in sort of senior exec disputes. So obviously this is going to be very relevant for what's in the content of the session today. So we just pop to the next slide, please. We are going to have a feedback form at the end of the session, and it'd be really useful if you can complete that feedback form. We are, for those that complete the feedback form, going to send an AI-generated schedule loss and an AI-generated grievance. So that's going to really assist with some of the worked examples we're going to go through. And also, we want to keep delivering really good content for you as our followers. So if you can complete that feedback form, then that's just going to help us deliver good content going forward. Can we go to the next slide, please? Obviously, to make it as interactive as possible, we're going to use Slido today. So if you can just get your phones out and follow the QR code that's on the screen. If you've not used Slido before, it's quite straightforward. We're just going to ask a series of questions throughout the webinar. If you can interact, respond on Slido to those, it just gives us sort of live information and helps the content and steer the conversation. So that would be really helpful. So I'll just leave that on for a couple of seconds so you can just do that before we move on to the next slide. Whilst you're doing that, I'm just going to walk us through the overview, which is going to be on the next slide of what we're going to cover. So the first couple of bits are going to be understanding AI in the workplace, so how employers and employees are using the AI tools and some of the common misconceptions about them. We're going to look at the key indicators that content has been generated via AI, and a lot of you are probably nodding along, but what you really come for in this session are the third and fourth bullet points there. So actual practical steps when we do get an AI-generated grievance, what can we do to assist you in dealing with those? And similarly, if you're getting AI assisted employment claims, be that the claim itself or the correspondence throughout the matter. So that's going to be the real focus of this session and the takeaways for those that are attending today. And then we're going to briefly look at the data protection and privacy risks associated with AI tools and what you can do to minimize those. So obviously spotting the AI is probably the easy bit, but cutting through its usage is really the key. And that's, as I say, the focus of this session today. So I'm going to hand over at this point to my colleague Jo, and she's going to discuss what AI is and how it is being used by both employers and employees. So over to you, Jo.
Morning, everyone. So what is AI? So there isn't a single agreed definition of artificial intelligence, but essentially it's how computers mimic human intelligence by recognizing patterns, learning and reasoning. Now, AI has been around for a number of years in various different guises. So you have your virtual assistants, your voice recognition. But what we're going to look at is generative AI, which is the type that creates content, and in particular, the large language models. So that's your Copilot, your ChatGPT. These are based on analysing a large amount of data to find patterns and make predictions. So with your large language models, it takes lots of text and then uses algorithms to predict word sequences and generate quick answers. And it does this by summarising information quickly and producing human-like responses. And it takes out that human thinking. If we can have the next slide, please. So before we go on to discuss this, we're just going to move over to Slido. So hopefully you've all been able to log onto that and just ask a couple of questions just to get a bit of an understanding around your current usage. So it'll just take a couple of minutes to load. Not sure if it's loaded yet. Oh, perfect. So as employers, do you currently use some form of AI? Yes, no, not sure. I've got quite a few answers already, which is great. Fantastic. And then just moving on to the second question, where you do use AI, is it available to all of your staff or is it just limited? Brilliant. Mix. Mostly all staff seem to be able to have access to it when it's in your when it's in the company. Brilliant. Thank you very much for that. So we'll just head back to the slides now. So as mentioned, there is a lot of employer use of AI. Just take a moment to load. Brilliant. And you can see that it's across businesses of all sizes. So over 2/3 of large employers seem to use AI technology for at least one area. And it's used in various ways. So that can be recruitment, task allocation, monitoring staff, and performance management. And this has been primarily where a lot of the discussion has been around about the use of AI and monitoring employees and the lawfulness of that. However, there hasn't been a lot of conversation around how it's being used against employers, which is the main topic today. Next slide. So the employee use of AI. So based on a recent survey, it works out that it's anticipated around 4 million staff are using AI in the workplace, and just over half have heard of that generative AI, which is the focus of today. Now, of those that use the AI tools, you'll see that around 30 are using it on a weekly basis. But there are a lot of misconceptions about AI use. So nearly half of all people believe that AI to be factually correct, and over a third believe that its answers are unbiased. You're also finding that employees are quite concerned about AI use when they're asked about it. So you can see a majority of them expect that it's going to reduce the number of jobs available to them or replace some part of their job role. In a recent survey, a majority of the employees who responded to explain that they were uncomfortable with the use of technology that could be used by their employers to manage them. So that shows a real disconnect between employees being uncomfortable about AI and having anxiety over it, but equally ready to embrace it when it serves their own interests. Next slide, please. So some common signs of AI use. Some of these you might already be aware of, particularly if you've come across some AI generated content before. So the first is typography. You'll quite frequently see use of em dashes, which can feel excessive in the content, and it makes the text look cluttered. The formatting, so you'll find that subheadings will appear in bold and you'll have title case, which will be inconsistent with the way matters are previously written. AI loves superlatives and overblown language, so it will use exaggerated phrasing such as unprecedented or game-changing, and it will sound over the top and be disconnected from the content of the document in any event. And it's also unnecessarily long. It seems to adopt the approach of why use 10 words when you can use 50. One of the most common signs of the use of AI is it doesn't sound like the employee. So particularly if you engage with the employee on written correspondence and you get this AI document, it sounds entirely different and it doesn't feel like that individual and a lot more generic. And you'll also see that it sometimes quotes legislation or case law. Some of those references can be made up or irrelevant, even if they are legitimate cases. Next slide, please. So this is just an example of what we've come across where a client's employee refused to attend a disciplinary hearing and they quoted their human right to a fair trial without actually having any understanding on the broader context. So Human Rights Act doesn't apply in the private sector and it isn't generally relevant in the public sector for disciplinary procedures either. So this is just an example of AI has sort of pulled on something and given a convincing spiel about why this individual shouldn't attend a disciplinary hearing. It sort of cements their position, particularly if you couple that with their belief that AI is always correct. Just on to the next slide, please. And this is just another example. So AI imagery is in its infancy at the moment. So you can see this looks quite obviously fake. So for example, if you look grilled salmon's £3 and the total doesn't add up, but it's showing that this is the next capability and the next development. Most companies will allow staff to claim expenses by submitting images. So unless someone's actually checking this, it would be quite easy though for this to slip through the net because it is just an example of a receipt without anyone actually looking at the detail. Next slide. I'm just going to hand you back to Andy.
Thanks, Lisa. Can we just go back over to Slido for a couple more questions ahead of doing the AI generated grievances section, please? So just ahead of time, so the questions that are going to come up on Slido are going to be, have you received a grievance that you think the employee has used AI to draft? And if you have received an AI-generated grievance, have you found it more difficult to resolve? So here we go. Interesting. So I thought the numbers would be higher in terms of the yes, but nice that there's plenty of you out there that haven't had an AI generated grievance land on your desk yet. So that's great. So we can just go to the next one, please, Lisa. So if you have received an AI generated grievance, have you found it more difficult to resolve? Again, pretty overwhelming that has created more difficulty. Perfect. Okay, so we could just move back to the slides, please. And I'm just going to sort of walk through what we've recognised or seen in terms of AI-generated grievances. So we've seen a real surge of them in the last, well, I'll probably say 6 months or so, and we've had to give a lot of advice to our employer clients who've received those. So it's for those employees, they feel like they've been treated unfairly or they have an issue at work. They are turning to these AI tools, so ChatGPT, Copilot, and they're writing these grievances on their behalf. So some of the ones that a lot of you have seen have been, I don't know, I'm really unhappy at work. I've recently discovered I've been really unhappy for many years. This can't be my fault in any way whatsoever, so it's got to be yours as the employer. And to prove that, here's a 20-page list of all the knocks and bruises and disappointments that I've been subjected to here at the employer over the last decade. Wow, thank you. So AI's made that process a lot easier for the employees. With just a simple single prompt, AI can generate a grievance letter of whatever length they want, a certain number, a certain word or pages within seconds. They can even instruct AI to write it in the writing style they prefer, so formal, assertive, highly legalistic, for example, and as you're going to see from the worked example we're going to do, can be highly aggressive in its tone to give it more weight and make it more serious. As Joe's alluded to, AI tends to amplify the message using dramatic language, makes lots of assumptions, which will drill down into more detail, and includes sometimes details that make it more severe. So in terms of the work for the employee, it's minimal effort to produce a substantive grievance, but it's maximum disruption for the organisation and with very personal input from the employee themselves. And obviously the repercussions are it increases the time and resources needed to deal with those issues, and they're often longer, more detailed, and are written in a way that's potentially more legally complex. We'll come on to it, but often dropping in a load of case law, for example. And then sometimes it just blurs what the actual issues are and how serious they are, given that AI can sort of exaggerate and further make assumptions. It's not all bad. I think, as Joe's alluded to, it does often do a lot of subheadings. So sometimes it's unnecessary wording, but then when it actually has relevant points of grievances, it can sort of summarize those quite succinctly. So it's not always all bad. So if it's used in the right way, it can help employees sort of structure what their concerns are and actually might help you as an employer. The irony is that you can probably use Copilot or ChatGPT to actually probably run that grievance, regurgitate it, summarize it, and actually give you a starting point to then go back to the employee with, which we'll come on to. So we just pop us to the next slide, please, Lisa. So to give some life to this, we're going to use a real worked example or hypothetical example. So this is an AI-generated grievance. We asked AI. So the background is, I'm employed in customer services. A customer has complained about me and said that I swore at them during the call. I didn't. I believe they've complained because I rejected their complaint. My employer investigated this and gave me a final written warning. This is unfair. I am a lesbian. Please write me a long grievance letter to my employer, identify laws it has got wrong, make it sound aggressive. Okay, so we're going to circulate this, the full grievance for those that complete the feedback form. But simply this was the prompt that's put into Copilot. As you can see, there's minimal information about the facts as to actually what happened. So we just pop to the next slide, please, Lisa. So the letter then raised 7 issues. So I'm just going to probably focus on 5 of the 7 issues. It's true to say that the letter itself wasn't particularly long. I think it ran to about 2.5 pages. Not really surprising given the little information that we actually had to work with. But it actually has done a lot with that information. It's made it much more legalistic on the surface anyway, of what you'd normally expect to see from an employee. And then, as Joe pointed out, there's some obvious clues, title case, bolded subheadings within the grievance letter itself. As I say, I haven't got time to go through the whole entire letter, but I'm just going to highlight a few of the points to demonstrate how AI has taken some substantial leaps from the initial prompt that was given. So we just pop to the next slide, please, Lisa. So the first one, if we just go back to failure to conduct a fair and impartial investigation, please, Lisa. So let me just go on one too many. Thank you. So I'll just read through the following 4 bullet points. So I was not provided with full details of the evidence against me, nor was I given access to any call recordings or transcripts that could substantiate or refute the customer's claims. I was not afforded a genuine opportunity to challenge the customer's version of events or to present my own evidence. No corroborating evidence was presented. There were no witness statements, no independent verification, and no objective basis for the allegation. The context of the complaint was ignored. The customer's complaint was rejected by me in accordance with company policy, providing a clear motive for a retaliatory allegation. It doesn't take a brain scientist to work out this massive leap from AI there. AI has gone as far to say that the investigation was manifestly inadequate, stating that full details of the evidence were not provided. The call recordings were not given. There was no opportunity to challenge the customer's version of events or to present evidence. There's no corroborating evidence of this. It was not included in the prompt. AI has simply made this up. Okay, next slide, please. So disproportionate unjustified sanction. So I'll just read this element out as well. So a final written warning is a severe disciplinary sanction, typically reserved for cases of gross, we'll just park that one there, or repeated misconduct. In my case, there was no prior warning, no evidence of any pattern of behaviour, and no justification for bypassing the normal disciplinary steps. The decision to issue a final written warning in these circumstances is grossly disproportionate and contrary to established employment law and best practice. And then touching on that case law, they've referred to a case called Falahi and TWI Limited, which makes clear that a final written warning must not be manifestly inappropriate and must be issued in good faith with prima facie grounds for doing so. In my case, there was no reasonable grounds for issuing such a warning, and the process was not conducted in good faith. So I'm just going to break that down into 2 parts. So the first one is that it states a final written warning is a severe disciplinary sanction, typically reserved for cases of gross or repeated misconduct. So dismissal, as we're all aware, is the usual outcome for cases of gross misconduct, not a final written warning. So AA's obviously got that wrong. And then in terms of quoting of the actual case law, yes, the case law exists, so that's a tick for AI. But then if we delve into it and what we use PLC in our world, so the EAT considered it was fair for an employer to move straight to a final written warning in a poor performance case in the case of Falahi and TWI Limited. The EAT upheld the tribunal's decision that Mr. Falahi was fairly dismissed. It did confirm that the tribunal did not err in deciding that it could not look behind the final written warning unless it was manifestly inappropriate. The manifestly inappropriate test was not limited in misconduct cases, but could be applied more generally when a tribunal considered whether it could look behind a final written warning. So AI's kind of used it to its best use in that case, but again, there's just not enough within the prompt evidential to support what AI has come to the conclusion upon. So we just move to the next slide. Perhaps the biggest leap in all of this from AI is the potential discrimination. So from simply stating that the employee is a lesbian and therefore has a protected characteristic on the basis of sexual orientation, AI has come up with the following. I'm a lesbian and concerned that my sexual orientation may have influenced the way this was handled. The Equality Act 2010 prevents employees from discrimination, harassment and victimization on the grounds of sexual orientation. Less favorable treatment because of protected characteristic is unlawful, whether direct or indirect, intentional or not. The fact that I've been singled out for harsh treatment with no evidence and no proper process raises questions about whether unconscious bias or prejudice has played a part. Employers have a legal and ethical duty to prevent discrimination and promote inclusivity. The law requires you to ensure that all disciplinary processes are free from bias and the employees are not subjected to detriment because of their sexual orientation. The Equality Act 2010 applies to all stages of employment, including disciplinary proceedings, and prohibits both direct and indirect discrimination, harassment, and victimization. I feel like I need a rest after that. That was all triggered from a prompt, I'm a lesbian. Okay, so that's quite disconcerting that AI can make the substantial leaps from just assuming that because of that protected characteristic of sexual orientation, that then means that they've been discriminated because they were a lesbian. It has, however, identified the correct legislation in terms of the Equality Act and specifically discrimination, harassment, and victimization. But again, there's no real application to the facts, given all we've said is that they have that protected characteristic. If we could just move on to the next slide, please. So this one is damage to my reputation, well-being, and trust. So this process has caused me significant distress, damaged my professional reputation, and undermined my trust in management. The imposition of a final written warning based on an unsubstantiated allegation and a procedurally flawed investigation is not only unjust, but has caused me considerable anxiety and stress. So again, it's made assumptions about how it's impacting the individual and put together a strongly worded paragraph in the grievance. Probably the final 3 words there, anxiety and distress, is then probably raising red flags with any of you sort of in HR, that are they potentially then introducing another layer of complexity and another potential limb of claim, maybe some sort of disability discrimination potentially, or the stress that it's caused. So we just move on to the next slide, please. And then the remedy sort is probably the hardest hitting. And then if we look at that 5th bullet point there, that's what they probably need to do, which is a meeting to discuss the grievance at the earliest opportunity, at which I'll be accompanied by a colleague or trade union rep, as that's my legal right. So bang on, I'm happy with that. But then if you look through the other bits, they're obviously a bit harder hitting. So immediate withdrawal of the final written warning and removal of all records of this incident from my personal file. A full written apology acknowledging the procedural failings and the distress caused. A review of your disciplinary procedures to ensure compliance with the law and best practice, including specific training for managers on the requirements of the Equality Act 2010 and the Acas Code, and confirmation that I will not be subjected to any further detriment as a result of raising this grievance. So it's very aggressive in its tone, demanding immediate steps taken without looking at the grievance itself. So as I said, point 5 probably needs to be pushed to the top to be dealt with first. And it's unrealistic, I think, on my assessment, very antagonistic. And even if the complaints were upheld, which is highly unlikely, but obviously we don't have the full background, they're unlikely in any event to get a written apology. AI, a couple of ticks for them. So they have quoted correctly from the Equality Act and the Acas Code, and they have obviously dropped onto the fact should be accompanied by a colleague or trade union rep at the grievance meeting if one is to take place. Next slide, please, and to discuss the next steps. So we sort of set out a summary of the process to follow if you do receive an AI grievance. So this slide is just going to focus on the first 3 of those. So what do you do if you think you've received an AI grievance? You obviously need to acknowledge that employees have the right to raise those concerns and you can't stop them from using AI. We'll come on to that in a bit in one of the later slides. It's important not to dismiss these concerns simply because you dislike the tone in which they're expressed or you suspect they have been using AI, okay? It's entirely possible that they do have a legitimate grievance, and as I said earlier, there are some instances where employees will use AI and actually it will quite nicely summarize what their grievance points are, and it is a good working document to work from, but I suppose it's what the motivation is behind the grievance. And in terms of the third point, we need to understand what the issues are. So we need to understand what the underlying issues are, what's going to resolve the issues or the concerns of the employee, and establishing whether that's achievable for you. So I'm going to look at that in more detail if we can just move to the next slide. So I think this is probably the most crucial part of the talk from my perspective, is how can we cut through the noise? How can we get to what we are seeking to resolve with the employee? So in a best case scenario, we're going to meet with the employee. We want to meet them face to face if possible. We need to find out what the issues are to understand what's going to resolve them and whether that's achievable for you as the employer. And we want to, as I say, face to face is the best way of doing that. We need to obviously follow good practice, so follow your grievance policy and the Acas Code of Practice, stating employers should always seek to resolve grievance issues in the workplace. So when you do get to meet with the employee, you need to ask them to explain their concerns in their own words. That's the crucial part, and how they want to get it resolved. I think so often people just raise grievances, but they don't actually say what the resolution is that they're seeking. Again, this can help cut through the noise and the length of the grievance and getting us quickly to the key issues. Just a reminder, you're not bound to resolve it in exactly the way the employee wants, but if you don't ask the right questions, you're not going to know if their desired outcome is closer and more achievable than you think. So always bear that in mind. You need to understand what it is they are complaining about and what they want to achieve. So we need to focus on the issues that we can sort of fix. And obviously, if we look at ACAS guidance, good employee relations, any investigations must be conducted reasonably. And then to frame that, I just refer you to Section 3 of the Employment Rights Act 1996, which says to provide a means for an employee to seek redress for their concerns, which is obviously to resolve a remedy or a problem. So the implication of that is that grievances should relate to issues that can be reasonably addressed. So if the complaints are either too historic, impossible to investigate, if staff have moved on, or there's been deletion of data, for example, it's irrelevant to the core issue, or it's too minor to justify a remedy, even if it was substantiated, they're unlikely to warrant a full investigation. Go back to the 3 R's, which we remind all our clients of. So is it within the range of reasonable responses? If so, they need to focus on matters that are recent, relevant, and resolvable. So just have in mind those 3 R's when we're looking at these grievance procedures. So what's the takeaway from that? You don't necessarily need to respond to each and every issue line by line, but if you decide not to investigate elements of the grievance, you need to tell the employee that the reason for that and why you've reached that decision. At this point, I always say to clients, what is the resolution they're seeking? So in some of our clients' handbooks or grievance policies, they might have a mandatory mediation first if it's applicable. So we've had a recent example where the individual's been sent off to occupational health. The recommendation is that they should mediate from the occupational health specialist in good faith, but then the employees turned around and said, well, I haven't got a grievance with an individual, it's with the legal entity of the business as a whole. So one of those that it's just a non-starter. What were they angling for was probably settlement. So is it the grievance going to resolve the matter, or could we go through mediation? If it's just a disagreement between two individuals, why don't we sit down, get people to talk to one another? Hopefully workplace mediation could provide that resolution. And if not, it's been a good step if there's potentially a future employment tribunal claim. And then obviously, having acted for a lot of individuals, it's often a tactic to leverage a settlement discussion on an open basis against then a without prejudice discussion, which is potentially off the record until settlement terms are reached. So again, let's get to the key points quickly. What is the resolution we're seeking? Can mediation work, or is settlement a viable opportunity? So we just flick to the next slide. We're going to look at that situation where they won't attend a meeting. So I think this is where probably the greatest frustrations are for you that do get AI generated grievances or a lot of AI generated correspondence back and forth. If the individual won't meet with you, you can't be face to face with them, then you are at risk of having reams of AI generated correspondence coming back to you very quickly, being very lengthy in nature. And this often happens if they're off sick, for example. So we just need to adapt our approach. So we need to pinpoint the core issues and identify a clear path to the resolution. So to manage this effectively, our advice is to clarify the issues yourself first. So again, we can go back to maybe running it back through AI, for example, summarize what the actual scope is of their grievance, and then present that summary back to the individual to confirm your understanding of their grievance. So there's a bit of an irony in that we're using AI back against them. And then once you've established the scope is then to ask specific questions or request particular details. You can't be specific enough, I don't think, in these instances, so you can get the relevant focused information. And then don't be afraid to set expectations around communication. You just need to politely but firmly explain that concise and clear responses are going to help resolve the matter effectively, and that hopefully will reduce the volume of unnecessary detail and just keep the dialogue productive and ongoing. So I'm going to hand you back to Jo, and she's going to go through the AI-assisted employment tribunal frustrations that many of you are seeing.
So before we go on to discussing those, we're just going to pop over to Slido again, just to ask whether any of you have received an employment tribunal claim or been involved in litigation where you think the employee may have used AI. So it may well be following on from the people who have received grievances that are AI generated. So it'll just take a couple of minutes to load, but you should be able to see the question already. Most of you haven't as yet. Okay. That's brilliant. Thank you. So we'll go back to the slide. So I do think I'm not surprised by that figure, because I think whilst grievances are more prevalent, obviously the tribunal claims are the next stage. So it does take a little while probably for those to filter through. But we are starting to see that there is an increase in tribunal claims, if we just go on to the next slide, that are being assisted by AI. And so we're starting to see that they're using the tools to draft their claim forms, to prepare witness statements, and to support them with other orders, such as calculating their compensation. And I think it was an expected development. This is mainly happening where the claimant is a litigant in person, so they're not legally represented. And you don't need me to tell you that employment law is complex and the tribunals are becoming more and more complicated. So if you couple that with a lack of free advice, it makes sense that individuals are going to look to alternative means to support themselves with going through this process. And obviously, we do have Acas, but we're finding that it's struggling to meet demand at the moment. So it's limited what they can do, and AI seems like a good alternative to them. Now, the issues with using AI that we're coming across are not the fact that they're using it, but it's the consequences of that. So first of all is the speed of responses. So we can be sending something out, we can prepare responses, have correspondence with the other side, and instantaneously within about 5 minutes from a detailed letter that we sent, we'll get something back from the individual. And that sort of raises a couple of red flags. First of all, have they actually looked at what we've said to them, had an opportunity to digest it? Probably not. And secondly, have they even looked at what AI has said in response to them, or have they literally just acted like a postbox and pinged it straight back to us? We've even seen an instance where claimants actually left in the line that says response prepared by AI. So they've not even read that point either. One of the problems with that is a quick reply doesn't get anyone any further forward. You'll find that the case is still at a standstill because they've probably not answered the question or agreed what was wanted. So we're just sort of going round in circles, really. There's also that assumption that AI is 100% accurate, and it's a bit of a dangerous thing because AI tools, as we sort of said, are not always accurate, and as Andy has alluded to with some earlier examples. And it's even less so going to be accurate when it's based on the details only that have been put in by them. So if they're putting in information in isolation, AI doesn't know the entire background of the claim. It only knows what has been put in that instance. So it makes it more likely that the AI response isn't going to be accurate or helpful. As we've also seen, employees aren't accepting that AI isn't always 100% accurate. So it's a bit of a challenge to try and explain that it isn't accurate, particularly when you're saying that from the other party to the dispute, so they're going to be slightly dubious of your intentions anyhow. We're also seeing instances of hallucinated tribunal cases. So it can make up tribunal cases to support its position, or it can refer to real cases that aren't relevant, as Andy showed you in an early example. The problems for that is you on the other side, or when it comes through to ourselves, is we then have to go back through and research those cases, see whether they are made up, what their relevance is. And then again, the employee isn't likely to believe us when we say it's not relevant or it's wrong. So again, we're not getting any further forward. One of the biggest problems with AI is it's a people pleaser. It's not likely to tell them that they have a weak case, and it's likely to exaggerate the compensation that they're going to get. And I'll touch on that in a moment. So it's unlikely that they're going to believe your position if they've got something that's saying, no, you've got a really strong claim. And AI generally tells people what it wants to hear, particularly when it's, again, lacking that full context. It's not going to provide a balanced view, in part because it's only receiving the information that the individual has put into it. This then creates bigger barriers later down the line. I'm sure you don't need me to tell you, a lot of time we look towards commercial settlements just because of the stress and expense of tribunal claims. And actually that's quite hard to do at the best of times, let alone when you've got AI in the background saying that their claim is worth millions of pounds, when in reality it probably isn't, regardless of the merits of it. So it's just protracting the process and making it harder for everyone concerned. And can we go to the next slide, please? So this is a real life case. If we just go back, that's it. So the employee brought claims of sexual harassment, sex-related harassment, unauthorised deduction from wages and breach of contract, and the tribunal upheld most of those claims. Now, her employer made an application for the judgment to be reconsidered on the basis that the employee had used ChatGPT to draft her witness evidence. So do you think the employer's application was successful? If you're watching, you've probably already just seen the answer because it jumped across quite quickly. Just go on to the next slide. So in short, the tribunal dismissed the application, and it was dismissed on a number of grounds, and one of which was the use of ChatGPT. All the tribunal said in relation to that was it was aware that the employer had used AI tools to generate her witness statement and had given consideration to this when it weighed up the evidence. Now, we're not sure what consideration it had given and how much weight it gave to that. However, it was worth pointing out that the employee, in this case, the claimant, was Greek and English wasn't her first language. So whilst we don't know why she'd used AI tools, it's feasible that that may have been one reason and could have been a factor for that. So it demonstrates that the use of AI doesn't appear to invalidate a witness's evidence. So again, going back to the problems that AI can cause of making things complex, referring to matters that may not be relevant, again, it's just adding to the problems potentially later down the line with the tribunal process itself. However, it is showing that courts and tribunals are becoming more alive to its use, and they're aware that many litigants in person are starting to use it. Now, just being aware of it, it doesn't suggest that there's going to be any changes in response to that. So we're very much dealing with the here and now of it seems to be accepted, at least at this moment in time. And there is a lot of discussion in the background about if there will be changes, but that's not got any further. Interestingly, whilst we're referring to claimants using it, there have been a couple of probably more high profile cases where legal professionals have used it and it hasn't ended up too well for them. So there was an instance where a barrister who had used AI to draft an appeal ground, it resulted in non-existent authorities and misleading submissions. And it was recommended that individual was referred to the Bar Standards Board. And likewise, there was a solicitor who faced scrutiny for false citations that were included in an amended grounds, again, most likely due to being AI generated. And it was recommended that the matter was referred to regulatory consideration. So there is a harsher line being taken with legal professionals compared to litigants in person, and whether that trend will continue does remain to be seen. Just scrolling on to the next slide. So we're just carrying forward from the worked example that Andy gave earlier. So following on from the grievance, it inherently follows that it could end up in a claim, and using the same information, we've asked AI to prepare a schedule of loss. So just by way of a reminder, it was about a customer making a complaint, said that the employer swore at them during a call, and they denied that they did that. They were given a final written warning. They considered it to be unfair, and they also cited that they were a lesbian. We'll send this around afterwards when you complete the participation feedback. You'll see there's lots of heads of claim. Now, most of them are correct, but it's arrived at some really obscure figures. So just scrolling down to the injury to feelings, it's saying that it's a middle band award of £7,500. Now, that falls within the lower band award. So the current Vento bands, so you get your 3 Vento bands for injury to feelings awards. The middle band's between 12,100 and 36,400. So it's really off the mark between what it's saying and what it's seeking. And it's also worth bearing in mind that you would only be entitled to an injury to feelings award if there was a discrimination complaint. So going back to what Andy was discussing earlier, there's been no suggestion, as far as we're aware, that discrimination played any part in that warning. It's just something that AI has picked up and ran with. There's also reference to aggravated damages, but these are only awarded in the most serious cases where the behaviour has been seen to be high-handed, malicious, insulting or oppressive. Again, so that just wouldn't likely apply in these circumstances, as there's no examples of malice or bad intention on the part of the respondent. So it's, again, AI taking something and running with it. You'll also see that there's a head for reputational damage, and that just isn't a head of claim. And finally, it's setting out legal costs if applicable. Again, it's very unlikely that costs are recovered in the employment tribunal. So whilst it's got some of the things right, it's also conflated other matters, introduced heads of claims that wouldn't be able to be pursued, and arrived at a figure that would be wholly inaccurate. And going back to what we said, it then becomes quite challenging to argue against AI, which is itself a people pleaser, and supporting the claimant's position. So just moving on to the next slide. So is there a solution? So just back. That's fine. So you cannot stop a claimant from using AI tools to assist them. You can't stop them doing it in the grievance process necessarily, and it appears either in the tribunal process at the moment. But once in the litigation process, one of the biggest problems is you seem to lose a lot of the control that you have when the matter is internal. Once it hits the tribunal process, we're in that external procedure, and we've sort of got to go along with it. So it's looking about how we can creatively address that and get to the underlying issue. The key problem appears to be that the employee isn't getting accurate employment law advice for the reasons that we provided. So it may seem counterintuitive, but some of the options that we should be exploring is encouraging that individual to take legal advice. Now, there is the Employment Tribunal Litigants in Person Support Scheme, and that does offer clinics to certain individuals provided they meet criteria. Alternatively, we could be suggesting to actually fund initial advice from an independent lawyer, similar to what we do when you ask individuals to enter into settlement agreements. But you could be saying, actually, we want you to go and take legal advice. And whilst it does seem counterintuitive to be paying for someone to bring a claim against you, actually it could save a lot of time and expense in the long run if you can put them in front of an individual that they're more likely to believe rather than the opponent, that just gives them a bit of a reality check on their claim, and it could bring settlement to close sooner. It's also worth bearing in mind what we can do in more of a preventative sense. So providing training to your existing staff and getting them to build awareness around the capabilities and limitations of AI. So earlier on, you mentioned that a lot of staff have access to AI in your businesses, and it's a good opportunity for the use of it, not just for your business, but to give them a wider understanding of AI. Understanding their strengths and weaknesses and trying to dispel this myth that actually AI is 100% accurate could help in the long run if they do turn to it to support them with their own matters. Just go quickly pop across over to Slido, and the question you should be able to see already is whether you provide training for staff about AI use, or whether that's something that you're already exploring or not. It might just take a minute to load at our end, but you should already be able to answer the questions. I think it's worth bearing in mind when that loads, it's trying to minimise the risk of AI being used and creating problems later down the line. And I think that's going to be especially important with the forthcoming Employment Rights Bill, which is going to introduce new rights and increase the potential for claims. So if we can sort of stop this at an earlier point. I'm not sure if that's loading. If it isn't
Sorry.
loading,
Yeah, sorry, it's not coming up, Joe. I'm not sure why.
if it isn't, we'll carry on to the next slide. But you can just pop in the chat if you already provide training, or if you consider doing so, about training, not just for their use with using it within the systems, but actually that more general understanding. So I'm just going to go on to talk about some data protection and confidentiality points. Just take a minute to load. Next slide. Perfect. So in addition to the problems that we've raised, or some of the challenges that you'll face with the use of AI by employees, there's also significant risks around data protection and confidentiality, and much of it depends on the systems that you may be using. So if you have an open system, which can be accessed by the public, so those are your public platforms such as ChatGPT, data that is entered by individuals can be stored and processed externally and potentially exposed to third parties. There seems to be a little bit of a lack of knowledge about how that can be used in the background. And it's worth bearing in mind that AI continually learns by the data that's put in from it. So it can be sort of using that data that it's harvesting for future iterations. Now, it's less likely to happen with closed systems. So if you've got private versions of Microsoft Copilot, they typically offer more secure platforms within those organizational environments. So whilst we can't stop employees from using AI tools, as well as training around the use of them and the reliability, it's also worth bearing in mind training them about what is acceptable use and protecting confidential data. So it should be that you can include that staff shouldn't be putting any confidential, personal or business sensitive information into open platforms, and you need to define what confidential information and personal data is, so it's really clear and transparent about your expectations around them. So that could be client data, financial information, employee details. Some of those things will be particularly relevant if they then start using it to form their grievances. It's also worth being really clear to employees about failure to comply with those obligations, and what we expect of them could result in disciplinary action. So any misuse of AI tools could be an example of gross misconduct and should be included in disciplinary policies. Again, it's just setting up expectations and providing a greater understanding. So I'm just going to hand back to Andy now.
Thanks, Joe. So if we just go on to the next slide, please. So yeah, just looking at a bit of a wrap up to some of the things that Joe's touched on and I've touched on. So one of the first things is actually auditing the AI usage. So when we did the Slido question at the start, do people use it? And people have said no. I suppose, do we need to drill into that? Is that actually the case, or are they just using it on their personal devices? Hopefully with some of the easy things to spot that we've flagged, you might reassess whether people are using that those AI tools in their day-to-day. And then, as Joe's just touched on about updating the company policy, so what is your stance on guidelines of AI usage? I think one of the clear things is the AI open or closed? So at Irwin Mitchell, we've got Copilot, but it's a completely closed system, so the data is not recorded anywhere. It doesn't go anywhere outside that, whereas there's a risk with employees just using ChatGPT, for example, that's not closed, then sensitive, trade information, employee data, customer information can be being sort of released into the ether, and then within the same AI tools. And some people have speculated on maybe pitches for tenders and things like that. Is that information already been disclosed by other parties putting together their own pitch information, for example? In terms of what is your policy, there's a great use of AI for, say, administrative tasks. For example, you want your employees to be more efficient, not doing mundane things that AI can help with, but actually doing the day-to-day work. Depends what the nature of the role, where's the line that you want drawn with that. And then what's the fallout? So again, Joe touched on your disciplinary policies. Do they need to be updated to cover this? Because obviously it's quite an evolving sector. And then is misuse of AI gross misconduct? And do we need to specify that in our handbooks and contracts? So that could be things. The scariest one's probably the data breaches, and that's something that we need to be really mindful of. In terms of employee training, I think there's a lot of that in the chat, and obviously I'll touch on that in the next slide. But I think that's another good preventative, proactive measure you can take. And then obviously, if you're then dovetailing that with the policies to support the same, then obviously you've taken good steps in that regard. And then with everything, it's that manager training. So is it being reinforced by the line managers? So our sort of back to basics suite of documents I'll touch on in the next slide. That can be very good. So again, spotting the AI the usage is probably quite easy, but then it's just cutting through, getting to the key points for line managers dealing with grievances. I think one of the questions flagged in the group chat was, what happens if they don't meet face to face? Hopefully, we've addressed that in some of the slides earlier. And it's just obviously AI can be used for good and can be used for bad, but ultimately we need to address employees' concerns. So maybe we just need to take a step back, appreciate, recognise they've used AI, but can we, as I say, cut through that with a face-to-face meeting, or can we improve our communication and the detailed responses and the narrow focus we're looking to try and get to a resolution for those individuals' grievances. So we can just move on to the next slide. So what resources have we got to help you? We've obviously got the full suite of our back to basics training. So the most common ones that are going to assist with what we've talked about today would be the handling investigations, handling the grievances, and probably potentially handling disciplinaries as well. So just getting your line managers confident to spot these instances and how can they then be proactive to sort of cut through the noise and get to the key points. We'll just move on to the next slide. So our commercial dispute resolution team, they're also looking at AI and how that's impacting businesses. So I think it's a week from now on the 12th of November. So if that's of interest, they're going to look at the impact of AI on litigation and how you can minimize the risks, what the future role of AI is going to be in the trends in litigation. And they're also going to take a look at some of the high profile cases relating to AI. So if that's of interest, there's the QR code there if you want to look at those. If we can just move on to the next slide. So we've got amazing professional development lawyers that keep you up to date. So if you haven't already, sign up to our newsletters, blogs, and then the podcasts, which Joe Mosley and Elaine do, and they're excellent. If you're just on a commute or something and you don't want to read through reams of information, just sit back and listen to those. One of the things that's just come to our attention in the last, I think, either yesterday or overnight, is that the new regs have been put before Parliament to extend Acas Early conciliation from 6 to 12 weeks, which I think for you as employers can only be a good thing. Acas are just completely overwhelmed at the moment, and I suppose because we act on both sides, and when we're acting for an individual, for the Acas conciliators to not get appointed until the 5th, 6th week, or sometimes they're just issuing the certificates, well, that's a really good way of actually seeing if there's a resolution at an early stage without people having to lodge claims. Because if ACAS is unsuccessful, you as an employer are getting landed with an employment tribunal claim, and then you're getting 28 days to respond to it. They're not going to change that 28 days. So if we can perhaps lengthen that window for ACAS and actually that be meaningful, and if there is a resolution, I suppose it's just then caveating that with everything that Joe said. If people are putting their claim values into AI, etc., again, can we cut through that? Can we discard any of the claims that aren't real limbs of claim, like damage to reputation, for example, which was in the schedule of loss? Can we be much smarter and use the ACAS conciliator that are independent to hopefully sort of guide that conversation and say, look, we are commercially minded, we are prepared to look at settlement, but what you're asking for is just not going to get an employment tribunal, and then you're potentially at risk of cost because you're bringing a vexatious claim. I say early stages, but I think that's a positive sign, and that could come in as early as the 1st of December. So if I just pick up some of the things in the chat. So I think, Dawn, you've raised a really good point about including a detailed form to ask the employer to complete to raise a grievance. I think that can only be a positive thing done in the right way. It's probably not going to be a one size fits all, so it might have to be a bit sort of changeable, or might have to be some discretion with that. You just essentially don't want to be able to restrict their ability to explain their grievance. So I guess the questions can't be leading, it needs to be quite neutral, but essentially we need to capture what's the nature of the grievance, what are the relevant, I don't know, dates, events, etc., and what's their desired outcome. So I think if that's well tailored, and it doesn't, say, restrict them actually raising what the grievance is, I think that can only be a positive thing. And yet a lot of questions about training, etc. So if you fill in the feedback form, there's follow-up there, and the back to basics suite's probably the starting point, or we can deliver bespoke training for your clients or your businesses in that regard, because I do think it's an area that some money spent up front can really cut down the time and resources that are being spent on these protracted grievances and tribunal claims. So I think that's pretty much it. So we just move to the last slide, and obviously that is the feedback form there. So just a reminder, if you do complete that, then we can send out to you the schedule of loss that was AI generated and the grievance that was AI generated as well. So unless anyone's got any further questions, I'm going to thank you for joining us today and wish you a very happy 5th of November.